Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why attorney CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Welcome to another episode of ElderTalk. I'm Jill Enders, and we are absent of Joe Cordell this week, but that's okay. He has a much-deserved day off. And today we are visiting with TuckerAllen attorney Missy Shands Manning. Your first time on the show, right?
Correct.
Oh, we are so glad to have you. Now, Missy, how long have you been with TuckerAllen?
I've been with TuckerAllen about 6 months now. I transferred from another firm that specialized in estate planning.
Okay, and how long have you been practicing estate planning law? Give us a little bit of your background.
Sure. I've been practicing about 7 years now. I graduated from Mizzou Law back in 2014, and I've been working in estate planning ever since. It's kind of my passion. I really enjoy helping all of our clients that present such different and unique needs.
And are you from St. Louis?
I am. I graduated from Kirkwood High School back in 2007.
I was going to ask you the St. Louis question. Where did you go to high school?
Mm-hmm.
So now what made you want to go into this particular area of law?
It's a really great opportunity to work with people a lot. Most attorneys don't get to see their clients very much and learn about them, but I actually get to meet all of my clients, and we get to talk about all sorts of facets of their life and how I can help them help their families.
And they're older, so they probably have a lot of information because they've been on this earth so long.
Some of them are. Actually, a lot of our clients are young and just had kids, too. So
really?
We have quite an age range in there.
So you find a lot of people come in that are younger that want to do estate planning?
Yeah, mostly after they had like their first or second child, they realize they need to have a plan in place for if something happens to them, they need a guardian.
Right. I know my husband and I, after we got married, and also just seeing some situations can go wrong and realizing how important it is to have an estate plan. So we got on the ball right after we got married. And this week we're talking, we're kind of circling back to a show we did with one of your colleagues a couple of times, Teresa Yao, about Medicaid and estate planning and how important it is to protect your assets
Of course.
if you're going to use Medicaid. And it can be kind of a complicated process, I would think.
It is indeed. There are a lot of rules and laws and regulations about how things can be handled, and they vary from state to state as well. So there's quite a bit of legal finagling involved to set up asset protection.
And, typically people think of a Medicaid recipient as someone that is lower income or middle class. But this can apply to even the affluent when it comes to financing long-term care.
That is absolutely correct. So although Medicaid is designed for people who have very limited income and assets, there are ways to plan around it so that even a moderate income family or a higher income family can still get the benefits of being on Medicaid while protecting their assets for their family.
So now how does this work? If someone wants to plan ahead and they're thinking, okay, in 10 years, I may need to go into a long-term care facility and Medicaid would be the best way to finance it. But I still want to leave my assets to my loved ones. How is it possible to do that?
So you would meet with an attorney like me, and we would talk about setting up a Medicaid Asset Protection Trust. So with a Medicaid Asset Protection Trust, you would set aside some assets of yours that you know you're not going to need to touch over the next couple of years. For example, an investment account or your house, probably not going to be selling that anytime soon. You would put that into a Medicaid Asset Protection Trust, and you would set it up so that way the money in there would ultimately still go to your children after you pass on, but until that time, it would be untouchable in there by you and any creditors like Medicaid.
So some people might think this is maybe pulling one over on the state, but it's really not.
No, it's designed to do it like this. It's perfectly legal. You put your money into the irrevocable trust, and that money can't be touched. There's a 5-year look-back period. So if you put the money in there right before you apply to Medicaid, then Medicaid is going to be like, oh, no.
Yeah.
But if it's been in there for several years and it's no longer your money because your name's not on it anymore, then you're perfectly fine and there's no problem with Medicaid.
That is something that Medicaid does check.
They do.
There's no two ways about it. You cannot get away with that, trying to hide your assets and then applying for Medicaid. They're
Correct.
going to for sure check on that.
Yes, so Medicaid really wants their money. They don't want to have to pay for someone's long-term care stay, which can be very expensive to the tune of like $7,000 a month for a nursing home when there's easily accessible assets for them to get to. The beauty of having a Medicaid asset protection trust is it's no longer your assets, therefore they can't count it against you.
Now, does this apply only to long-term care like nursing homes, or can it apply to, say, a retirement home, an assisted living, if you will, home?
So it kind of depends. Once you put the money into the trust and it's been 5 years, you're good to go no matter what, however it's going to be paid out because that money is protected. Medicaid can pay for only certain types of medical-related or nursing home-related needs. So Medicaid could pay for like in-home health, but if you're just going to be living in an assisted living facility and not needing any sort of medical care, then they're probably not going to be cutting a check for you to stay at this elite,
Right,
where you drive around on your golf course.
Now, what you described before about what you put into the trust, is that spend down or is spend down something different?
So spend down is a little bit different. So once you've set up your Medicaid Asset Protection Trust and you've put in all the things over there that you're not going to need to keep yourself afloat, you're free to continue living your life and using whatever expenses you need for your daily living. Once you get to the point where you are going to need long-term care and apply for Medicaid, you still have some assets there that don't fit into your irrevocable trust. For example, an IRA or other qualified retirement plan money. That money is still considered your money and has to be owned in your individual name. If you cashed that out back 5 years ago, you would have hit with a 40% tax rate.
Sure.
So that would not have been a good idea. So you continue to use that to live off of until you're ready to go into a nursing home. And then at that point, you do what we call a gift and annuity plan and a spend down. So you spend the money as much as you can on things that are exempt. So, for example, you can go out and buy a new car. Missouri exempts your car, and that's perfectly fine. Go buy yourself a really nice new fancy car. That's a perfect way of spending down some of your money and getting to the threshold limit without having to worry about passing it on to anyone else or the Medicaid coming after it. Another example is improvements to your home that you may have been putting off for a while.
Okay.
Paying down your debts. All of this purpose is to get your money down to the $5,000 limit in Missouri. Other states have different numbers, but Missouri's number is $5,000 right now.
You have to get rid of these assets. Now, can you transfer any of these assets for the purpose of spend down to somebody else, someone in your family? Say you have a bank account of $50,000. Can you go ahead and just put it in someone else's name, or does that not apply?
So that would be considered a gift if you just gave that money in the bank account to someone else. Generally speaking, you can't make gifts like that without incurring a penalty. The penalty is about 1 month of nursing home stay for every $5,000 or so worth of gift. But there are certain things that you can give to someone else. Like you can make unlimited transfers to your spouse. You can also transfer things like your house to a child who's been living with you and caretaking for you for 2 years, or a child who's disabled, or if there's a child in the home that's under 21, there's a bunch of exceptions to get around that sort of thing. But generally speaking, if it's not to an exempt person for an exempt purpose, then there's going to be a penalty period.
I can see why it's necessary to talk to an attorney like yourself about this because, again, like I mentioned, it is very complicated. Mm-hmm. Okay, you mentioned an IRA. Can you transfer that into someone's name, or do you have to use that to spend on, say a new car, as you mentioned, or home improvements?
So according to the law, your IRA must stay in the name of the worker because you accrued those earnings there. You can't transfer it to a spouse or anything like that because it's your money. But what you can do is you cash that out. Hopefully we have some heads up notice before you're going to enter the nursing home, and we can defray that over a couple of years instead of skyrocketing you up into the highest tax bracket for that 1 year. Then once it's been cashed out, then you can do one of these other options about spending it or gifting it away.
Now, at what point do you recommend someone starts the process for preparing for long-term care?
So ideally, I wouldn't say in your 20s, but as soon as you're getting older, your kids are starting to get out of the house or anything like that, you've got time for yourself to think about how you're going to take care of yourself in the future. So 50s are a great time, 60s are a great time, 70s, maybe we're getting a little later.
Yeah, it's pushing it there.
If you're in great health, maybe we could do it, but at the very minimum, we want to make certain that you have 5 years before you're going to end up on Medicaid.
But, even, say, someone in their late 30s or 40s, they could have some kind of health issue, a serious stroke, to where they would end up in a long-term care facility. So, really, you're never too young to do this, would you say?
That is very
20s,
true.
Yeah, I know.
Yeah.
But you do, at that occasion, unfortunate circumstance would happen.
Yeah, so sometimes things do happen and you get a medical diagnosis or an accident that will harm you for the rest of your life going forward and require some sort of care. We've had a client, unfortunately, be diagnosed with MS very young, so
Right.
we're doing an asset protection trust for her, so that way she's in good shape no matter how her progression of the disease goes.
Just out of curiosity, what's the youngest client you've had that came in for estate planning?
Oh my gosh. We've had some 18-year-olds, quite a few 18-year-olds come in.
You're kidding. That is a very mature 18-year-old. That was the last thing I was thinking of when I was 18. I was just thinking of which college I was going to. And they actually came in. I mean,
Most of the time it's their parents shooing them along, helping them out, making certain that, because they have a very vested interest in making certain that their kid is taken care of with something like a durable power of attorney or healthcare power of attorney.
Really? Okay, that is really interesting. So what happens when someone hasn't planned and they have some serious medical issue, a stroke, and they have to go into long-term care and they've done nothing? Then we're in panic mode, right?
Yes, so that's crisis Medicaid planning, and that's not a position anyone should want to be in. If you had thought about it in advance and you'd gotten everything set up with the Medicaid Asset Protection Trust, you would have been pretty well okay at that point to just go into Medicaid and handle things just fine. When it's a crisis situation like that, you're not going to be able to save nearly as much money for your family as you might have hoped. We've got to get you on Medicaid as soon as we can because otherwise you're private paying at the cost of $7,000 a month. So if they wait too long, there are things we can do to help out, to help preserve some assets. But there are things like caregiver agreements and maybe like a rental agreement if the person's not quite ready to go into long-term care right this second, if they're going to be with mom or sister or daughter or son for a month or two in the meantime. It's not a great position to be in.
So what do you mean rental agreements? Explain
So
that.
if mom or dad's no longer able to live by themselves, maybe we're not quite ready to put them in a nursing home, especially right now with COVID. Mom or dad can move in with someone else, and one way of getting their assets spent down to prepare them to get on Medicaid is to use a rental agreement. So they're renting the room from mom or dad or sister,
Okay.
whoever it might be, and then that rent money is paid out to whoever owns the home, and that person can squirrel that away in case, whoever it is needs that money later on.
So what happens to their house then? Say their house is paid off. Will Medicaid get that house?
So Medicaid only protects a house if it's going to be their primary residence that they're going to come back to. So if there's a chance that they're never going to be able to come back to that house or it's no longer their primary residence and they're living somewhere else, that house no longer has Medicaid protection.
They would get it after that individual passes away and then their spouse, correct?
If, let's call it mom is living with daughter and mom's house is no longer occupied by mom anymore, that's going to be a countable resource for Medicaid, and Medicaid's going to require that money to be spent before they'll accept mom onto Medicaid.
Oh, okay. So they would take it when the person, mom, goes into the nursing home. Is that correct?
Essentially, they're going to essentially deny her Medicaid application until the house sale value has been spent on her nursing home or home health care costs.
Okay.
So Medicaid won't cover anything until that money is gone.
Now, some people might not think that they will get good quality care if they're on Medicaid and going to a nursing home, but that's not true, is it?
No, we have a lot of people who think that. Just because you're a Medicaid patient doesn't mean that your doctor is suddenly going to treat you any differently than they were before. They're not going to necessarily throw you to the side and only focus on a patient that is a paying patient. Plenty of people are on Medicaid.
Sure.
No one's going to be discriminating against them. That's, illegal. They've got to treat you just like everyone else.
Say you go on Medicaid and you stay in the home, but you're receiving services such as, home health care.
Mm-hmm.
After your death, Medicaid can potentially collect, can't they? If you did not do any
sort of planning, yes.
But I hear that it's not, at least in years past, it's not always common for the state to come in and collect on it. It kind of slips through the cracks. But things are changing now. Is that correct?
That is very correct. So Missouri Attorney General's office and other institutions like that are much more aggressive about it now than they used to be. So anytime anyone opens a probate estate, they have to submit a waiver saying that that person was or was not on Medicaid. And if they were on Medicaid, then the Medicaid office gets alerted and they're going to come after all of the assets in the probate estate to recover part of the cost of that person's care.
If you're just tuning in, we have our guest from TuckerAllen, attorney Missy Shands Manning, and we're discussing Medicaid and long-term care and how to protect your assets. What happens, Missy, if someone, the recipient, owns a business?
Oh, so that one is a tricky one. So it's still possible to get on Medicaid with a business. It's a little bit more complicated. So the general rule of thumb is you've got to be making 6% of your equity in the business each year in income, net income, and they will only exclude up to $6,000 of your equity in the business. So if you have a small business on the side, or maybe it's service-based where the only real valuable part is what you provide, then chances are you're going to be good under these rules. If you have a business that maybe is based in real estate or has a lot of expensive equipment, then chances are the business is going to be worth over $6,000 and it's going to be counted as an asset. So let's take a few examples. Back in college, I paid my way through college and law school by running a in-home doll repair business for American Girl dolls.
You're kidding me.
It's ridiculous and silly, but I made quite a bit of money off of it, and that's how I got myself through school with a little bit of assistance from my parents. Back in the day, everything was my ability to help out. It was a service-based business, so I had very few actual equipment, storage things, anything like that.
Right.
So the value of the business was relatively low, but I was making probably $18,000 a year on net profit. So something like that, I'm certainly going to be over the 6% threshold there. I was making quite a bit of money over the equity I had in the business. I might have had $2,000 worth of equipment.
Quite the entrepreneur, I must say.
Thanks. And I was under $6,000 worth of the value of the business, so it would have been fine, and I would have been able to go on Medicaid if I needed to at that time. Take, for example, though, my mom's business. She has real estate.
Okay.
She's a landlord on the side. So if she needed to apply for Medicaid, chances are she'd be refused because of that business, because obviously a house has a value of over $6,000.
Sure.
So she may have been making the income threshold to prove that, she's making money off of the business more than you would for just a normal investment. But the value of the property was just too much money.
Interesting. You had a doll repair business, talent I didn't know you had, and you repaired American Girl dolls?
Yes.
Those dolls are very expensive.
They are.
So I have to ask, if I'm not being too nosy, but I am very nosy, how much did you charge to repair a doll?
Generally speaking, if they mailed the doll to me and I took care of it, I made about $25. But I eventually wised up and I created a video repair kit where I sent them all the materials and I walked them through how to do it themselves. So that way they could do it themselves and I didn't have to worry about shipping. And so I capitalized on it and that made a lot more money that way.
Did you ever have a doll you couldn't repair?
No. Actually,
I'm trying to imagine what did some child get really upset with the doll and smash the doll, or what type of injuries did the doll have?
So I don't know if any of the listeners have experience with young children right now, but usually the big one with dolls is someone got a haircut.
Oh, I used to do that, cut the doll's hair.
Yep, so replacing the doll's little hair with new hair so it all looks nice and neat and cute again.
Wow, okay. Well, very interesting business. I'm impressed. Let's continue about Medicaid. Now, with the pandemic, many are concerned with placing a loved one in a nursing home. And What advice would you give a client that came to you with those concerns?
So I totally understand those concerns right now. My own grandmother is in a nursing home, and there have been COVID cases there. And it is a very nerve-wracking time for us right now because,
Sure.
they're all very susceptible to it at that time if they're in a nursing home. Ultimately, doing home health care may be a better decision currently, but sometimes you just can't do that. It's just not something you can do because of time or because of money or because of the available space, stuff like that. And having an actual nursing home take care of the person is the only feasible choice. And if you need to make that decision and that's the way to go, it's going to be ultimately all right. There are many procedures in place in the nursing homes, and we do the best that we can.
Right. But if they do want to stay home, they can get home health care services, but that's not 24/7 that Medicaid's going to pay for that.
Correct. So they would still have to qualify for Medicaid, the same as if they were going to go into long-term nursing home care. So the same threshold limits apply on the $5,000 of assets.
Right.
The payout for home and community-based care is much, much less, though, than a nursing home, even though it makes more sense because ultimately, it's cheaper overall to keep someone in the home because they're not having to pay for renting a room and room and board and all of that stuff. At the end of the day, Missouri's home and community-based services just don't pay out nearly as much money as they would if it was in a nursing home.
Right. Unless I guess it would be someone, say, that has advanced Alzheimer's.
Mm-hmm.
And obviously there would be a need because most people can't be there 24/7. They have jobs, they have children, and maybe they can't afford private care. So in those circumstances, you're going to want them in a long-term care facility for their own protection.
Exactly. So sometimes you just don't have a choice. But if you can go ahead and keep them at home, Medicaid can help you out in that way. It may not be a ton of money that you're going to get from Medicaid to cover all the services that are needed, but if that's the best choice for your family, then Medicaid will at least help somewhat.
Now, since the pandemic started, have you had a lot of clients calling you and saying, look, mom or dad's in this nursing home. I'm really concerned. Should I pull them out of there?
Yes, actually, we did have one just the other day. Unfortunately, in that person's situation, they could not bring them home. But if you have a nurse in the family or they're willing to help out, someone is willing to chip in to help take care of mom or dad, in addition to getting Medicaid-based home and community-based services, maybe that'll be enough for someone to leave the nursing home and go into a more secure place to live.
Now, what is the situation where a family member can receive some sort of income for taking care of their loved one that's on Medicaid?
Theoretically, Medicaid can pay someone to take care of their relative. However, it is actually very difficult to do so in Missouri. It's just Medicaid doesn't like to pay relatives. It won't do it if it's a spouse at all.
Okay.
And then if it's like a caretaker child or something like that, Medicaid usually has a hard time justifying that. The easier way to get around that is to help spend down some of mom or dad's assets through a caregiver agreement. So child can get paid for coming over and taking care of mom or dad, an hourly rate to help them take their medicine on time, accompanying them to go out and pick out grocery shopping, stuff like that.
Okay. Now, how often do you come across where clients are in crisis mode, where they need Medicaid and they've done no estate planning? How often does that happen?
Quite a bit. We just had one come in recently. We had to get them set up with a guardian conservator so that son could start making decisions for dad and get him on Medicaid and spend down his assets. And then after getting a guardian conservatorship, then we had to also then apply for Medicaid, which again costs quite a bit of money to have to figure all that out and help them with spending down their assets and protecting what they can.
So I imagine that's a really challenging situation. And for you as their attorney to have to, perhaps deliver some bad news that, okay, this isn't going to work because of this and you didn't do this estate planning, I imagine it can be really tough on you.
Oh, yes. And it's financially hard on them and it's emotionally hard on everyone involved to tell them that if you had come in 5 years ago and set up a Medicaid asset protection plan for a fraction of the cost of what it would cost for 1 month in a nursing home, they would have been fine. We wouldn't have had to worry about a guardian conservatorship. We wouldn't have had to worry about how much we're going to be losing by going on to Medicaid. they would have been in such a better position. They would have been much more prepared emotionally and financially.
Do you think during this pandemic, people are realizing more and more that they do have to make these decisions in their life, that, you know, it's time to make an estate plan and to get a will or a trust because of what we're living through right now?
Oh, yes. We have had a lot of business ever since March, and the COVID became a huge national problem that has gained a lot of attention, and everyone's worried about it now. And we have lots of people coming in to set up estate plans or Medicaid asset protection plans, just because everyone is so concerned about what's going to happen to them, what's going to happen to their family.
And medical power of attorney.
Oh, yes.
That's probably a big one.
Especially with COVID, because someone's going to have to make a healthcare decision for you if you're incapacitated and you're on a ventilator. You can't talk. You don't know what's going on.
Right. And you want someone that you trust in place to make those decisions. Now, have you had a lot of young people coming in through this pandemic wanting medical power of attorney?
Yes, actually. Our clientele base spans the entire cross-section of the population. We've had 100-year-old people come in, and we've had people in their 20s.
Now, have you been able to meet with these folks virtually because some might not want to go, you know, because of the social distancing? Have you been doing it that way?
Yeah, about half of our consultations are either on the phone or virtually through Zoom or a similar sort of video conferencing. With those, we are even able to execute documents and not have them come into the office at all because of the virtual notarization executive order issued by the governor. So as long as we can see them through Zoom or FaceTime or something like that, executing the documents, then those are perfectly valid and they can get their estate plan done from the safety of their own home without having to ever see us in person and worry about COVID.
So digital documents. Correct.
So they're physical paper documents. It's just we see them sign it so we can notarize and witness. We do all of that virtually.
Oh, okay. And then what happens? Do they, with the documents, they have the physical documents and then do they send them to you?
Yes, because we have to sign our names on them as well to prove that we witnessed and notarized. And then we send them the completed documents all together through the mail.
Now, is it best for someone to keep their will or their trust with their attorney? I mean, the actual one, not the copy, the actual one.
Some attorneys do keep originals on file, but most of the time it's just a liability for law firms to keep all of those original documents there in case something happens. So almost overwhelmingly, people will take their original documents home. The attorney will keep an electronic copy or a paper copy, depending upon the law firm. We're an electronic firm over at TuckerAllen. And then if there's ever any question or we need a copy, we can print out as many copies as we need and we can file it with the court.
So if someone has their original copy and say they had a fire at their house and that will was destroyed, is it still valid because you've got a digital copy?
Yes. Actually, we just have to prove, we file an affidavit with the court saying that there was a fire at the residence at this time and it destroyed the will. Here's a copy of the original document, and that is exactly what it said in the original one.
Getting back to Medicaid, let's talk about how long after a person's death does Medicaid have to file a claim against an estate?
It used to be that Medicaid had to file their claim within 1 year. And then the Missouri Supreme Court decided that they were on the same level as the IRS and that they could come after someone's probate estate to recover for the cost of their care at any point as long as a probate case is open. So if no one files a probate case, then they can't really go after it unless they want to open one themselves. So that's kind of a loophole there. But if you open a probate case for mom or dad who was on Medicaid, Medicaid can then come on in and they're alerted because of that form they have to file now saying that person was on Medicaid. And then they can come in and get that money 5 years down the road as long as the probate estate is still open.
And let's talk about the exceptions. Say you have an adult child living with you that is disabled. And you have to go, mom has to go into a nursing home, father's passed on, and it's just that child. Will Medicaid still take that home?
No, they won't. Since there is a disabled child there, then they will not take the house from that child. And if mom wanted to set up a trust for that disabled child with all of her money that disqualifies her from Medicaid for having too much, she could put that into a trust for that child, and Medicaid wouldn't count that as her asset anymore either. So having a disabled child ends up working out very well if you're in that scenario.
Now, what if the child isn't disabled but an adult, but that child has provided care for that parent. Say that parent has been disabled for years from a stroke, and that child has been the caregiver. But at that point, that parent, say, develops Alzheimer's and has to go into a home. Will Medicaid then take the home?
No, as long as mom or whoever has her durable power of attorney, if she has Alzheimer's and doesn't have capacity anymore, transfers that to the caretaker child. To do that, though, you need to have the proper paperwork in order to get it through Medicaid because they're very concerned about that sort of thing. So before that transfer takes place, you want to get a note from a doctor saying that because of caretaker child's care for mom, the parent would have been in a nursing home at least 2 years prior.
Okay, so you have to have someone backing you up. You can't just say, oh, my child has been living with me all these years, taking care of me, because I could see where there would be some fraud.
Yes, so you want to make certain that you've got paperwork in order to back it up because your word might not be enough.
So is it just a doctor, or do you have to get, say maybe neighbors or other relatives to confirm this?
We recommend doing a doctor because it's going to be a medical decision if someone was going to have to go into a nursing home or not because of that, without that child's care. So it's a medical decision. Get a doctor to make the decision, not just some neighbor who thinks that they would have been in a nursing home without that person.
Okay, I gotcha. All right, so you have a husband and wife that are, say, in their late 60s, maybe early 70s.
Okay.
Husband has a stroke, has to go into a nursing home because the wife maybe has a few health problems of her own and can't really physically take care of him. So they apply for Medicaid for the husband. The wife can stay in the home, correct?
Correct. Once she passes away, though, the home is no longer exempt, and Medicaid can then come after the home after she passes on. But at least she's not kicked out of the home and she can stay there.
But if they created this estate plan, then their assets are protected.
Correct. So if they had set up an asset protection trust 5 years or more before he needed to go into the nursing home, then the house would have been in the irrevocable trust, and Medicaid couldn't consider that their asset anymore. So it couldn't have put a lien on it. It couldn't have taken it away at any point. And that house is protected. And once mom and dad pass on, then that house can be sold and the proceeds go to their kids.
I've heard Joe talk before, when you meet with clients that, with estate planning, it's best to meet with that client one-on-one as opposed to having all the family members there for that consultation. Do you agree with that?
Yeah, so one of the big things we worry about when we meet with clients is lack of capacity and undue influence. So if we have 5 kids in the room talking about what they want and how things should be set up, I might not actually get to interact with mom or dad and make certain that mom or dad understands what's going on and what they actually want. And then we always worry that the child is speaking for the parent without the parent actually wanting that.
Yeah, and I could see where a parent might feel uncomfortable speaking up about what he or she really wants because this child or children, adult children, are in the room and they wouldn't feel comfortable. So it is best just initially for the client and the attorney to meet alone. And then later on, is it appropriate? Does that happen where the adult children or other family members might come in?
Yeah, that's perfectly fine as long as we've established that mom or dad has capacity and what mom or dad wants without having the kids in the room. Then they can come back in and talk about anything they want, but it's very important because we could lose our license if we're creating an estate plan for someone that doesn't have capacity or is clearly under undue influence.
Do you ever have clients that insist, my son's coming in or my daughter's coming in or else I'm leaving?
Generally, they understand if I explain it to them, and no one usually has a problem. Usually, the kids are happy to step out and let me talk to the client by themselves. I've never had anyone throw a fit and say that they're going to leave. And I think that if that was the situation, that might be maybe that's for the best.
Yeah, right. Now, what about with advising the client on a trustee and they have several children? That can be a tough one.
That really can. So some of the options are to name all of them as co-trustees. Some of the drawbacks to that approach is that when you have 3 captains at the helm of the ship, we're either making multiple decisions or we're not making any decisions at all because people can't agree.
Too many cooks in the kitchen.
Yes, so it is often easier if you just choose one child that you truly trust, that has your best interest at heart, that has good financial sense, good common sense, and a head on their shoulders, to be the person that's going to be your successor trustee. However, some families are not able to choose just one, and if we need to, we can always do multiples. We just need to be very clear in the document on what happens if they disagree.
What about with medical power of attorney? Can you have more than one in that role?
Yes. So any document, you can list more than one person. Again, though, we still run into the problem of too many people having to make a decision. So maybe child A says, we can't authorize this procedure. Mom wouldn't have wanted this. And child B says, well, Mom told me that she wanted this 10 years ago. And child C is like, I don't know. So having to get all three of them to make a decision together, especially when there's a clock ticking and a decision has to be made, it can be very difficult.
Well, how do those conflicts get resolved? Because I'm sure that happens all the time, and the clock is ticking. I mean, is this the type of situation where a judge is brought in, or?
If necessary. A lot of times, though, it gets resolved because the hospital facility comes and kind of badgers everyone into making a decision together, which isn't always the best way to make the decision, but if it needs to, it can be escalated to a court, and then someone applies for guardianship and says, I'm going to be the one making decisions for Mom now.
Now, a trustee can be a non-family member. It can be their attorney, correct, or a financial institution?
Correct. So oftentimes attorneys will not take on a duty of being successor trustee just because there's some personal liability involved, and a lot of companies are very adverse to that. But sometimes an attorney will do that. I, for example, have been a trustee for someone before. However, the better option is usually to have a corporate trustee. So like Commerce Bank has a trust company, Wells Fargo has a trust company, and those people will take care of doing everything as trustee for you.
Okay. Good advice. Good advice. And we don't have a whole lot of time left, but if you are just tuning in, we have TuckerAllen attorney, I might add, Missy Shands Manning, and we're reviewing Medicaid and long-term care. We did a show about this earlier in the summer. It was one of our more popular shows. So again, let's go over some things, review what we talked about, especially when you want to start making these plans to protect yourself from Medicaid, your assets. What point in your life would you recommend?
So as soon as possible. There's no harm in getting it done when you're young. Don't put it off, because if you wait too long, then you're in a crisis planning mode and you're going to be losing out on a lot of money and time and getting a lot of extra stress put upon you.
And Medicaid looks back 5 years.
Correct. So 5 years after a gift.
And what you want to do is create a trust and put those assets in there. Talk about what those assets are again.
Sure. So you want to put everything into your irrevocable Medicaid asset protection trust that you don't need for your daily living. So, for example, your house, you don't have to continue to own that in your own name. The irrevocable trust can own it for you, pay the real estate taxes, all of that good stuff. Another example is an investment account. If you don't need that investment money to keep yourself afloat month to month, put it in the irrevocable trust. 401ks and other qualified IRAs must remain in the name of the worker. So unfortunately, they cannot go into a irrevocable trust. In Missouri, counts those assets for Medicaid, but there are ways to get around that with a gift and annuity plan. But pretty much everything that you can sacrifice will go into the irrevocable trust and be protected after 5 years, and anything else that you need for your day-to-day will stay with you.
And it doesn't mean that those assets aren't yours anymore necessarily because they're in a trust, correct?
So theoretically, those assets are owned by your trust. So they're not yours anymore, but ultimately you have some degree of control over them.
So you can get, say, some funds out of there, but you would have to go through your trustee, is that correct? In
a Medicaid asset protection trust, none of those assets can be used for your benefit. However, the way we think to get around that usually is that money can be distributed to your children, and if your children so happen to decide to help out mom, then that's fine.
Okay. And then when you come to that point and you've done all of this planning, you've created this trust, then what comes next would be spend down.
Correct. So any assets that you have, like that 401k or day-to-day assets that you needed for your own living expenses, those all need to be spent down to $5,000, at least in the state of Missouri. So spending down means using that money in some constructive way through buying a new car, spending on home repairs, making an exempt gift to your spouse or a disabled child or a caretaker child. And then whatever is left, you can make a gift to your kids or someone like that. And then an annuity would cover the penalty period for that gift. And you would use that to private pay until Medicaid takes over.
You could even help a grandchild out with college tuition, I would think.
Yeah, that would be great. What a good use of money.
Mm-hmm. Okay, well, Missy, we are so happy that you joined us your first time. So thank you again for joining us. That was our guest, TuckerAllen attorney Missy Shands Manning. Until next time, this has been another episode of Elder Talk. Take care. You've been listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future, with attorney CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of Elder Talk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.